To order. Welcome to meeting number 4 of the Commons Standing Committee on Justice and Human Rights, pursuant to Standing Order 1082. Again, in the motion adopted on September 23rd by this group, the committee is meeting to begin the study on bail, sentencing, and the handling of repeat violent offenders. Today's meeting is taking place in hybrid format, pursuant to standing orders. One member is attending virtually. Welcome, MP Housefather. Avant de continuer, j'aimerais encore une fois demander.
Before we continue, I would ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio feedback incidents and to protect the health and safety of all participants, including the interpreters. You will also note a QR code on the card which links to a short awareness video that you have perhaps already consulted.
Of witnesses and members here today. Please wait until I recognize you by name before speaking. I sometimes do so informally, but you should get a sense of where I'm looking. For those participating by video conference, just click on the microphone to activate the mic, and please mute yourself when you're not speaking. For those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either floor, English or French, depending on your preferences. And for those in the room, you can use the earpiece and select the desired channel. Mine or all comments should be addressed through me, the chair. Tous les députés présents dans la salle, si vous souhaitez prendre la parole, veuillez lever la main.
For all members present in the room, please raise your hand if you wish to speak, and those on Zoom use the raise hand function. The clerk and I will attempt to maintain a speaking order, and we thank you for your patience and your understanding in this regard.
3 witnesses for today's meeting that did appear on short notice, given that we... C'est la traduction?
You can't hear the interpretation? It's not working?
Not.
No, it's just that in your introductory notes, I just wanted to ask you, I don't want to interrupt the witnesses. Everything's fine. Thank you.
Une plainte, là. Okay, no.
Unless you have a complaint? No, we've just been asked to mention it. The sound tests, and you're telling me that it's been done, and I don't want to bother you with that, Mr. Chairman. That's fine. Thank you.
So today, and thank you to the witnesses for appearing on such short notice, as we decided on the priority of this. Even it's obvious, but we did choose this as a priority item only on Tuesday, so thank you for appearing on so little notice. Today we have from the Association Canadienne des Policiers, Tom Stamatakis.
From the Canadian Police Association, the National Police Federation, Brian Sauvé.
And from the Toronto Police Association, Clayton Campbell, as president. Again, thank you all 3 for your service. I remember the witnesses. I will remind the witnesses that you have 5 minutes for your opening statements, followed by questions from members of the committee, as we have adopted in previous meetings, the time length restricted to each member. I'll go in the order that I presented you. So Mr. Stamatakis, you first, and then Mr. Sauvé second, and then Mr. Campbell third. So without further ado, thank you, welcome, and please go ahead.
Thank you very much, and good afternoon. Thank you for the invitation this afternoon and for allowing me to appear on behalf of the Canadian Police Association, which represents more than 60,000 frontline police personnel across Canada. Our members include civilian and sworn law enforcement professionals serving in every province and territory, and large urban centres, as well as rural and remote communities. Collectively, they bring a perspective that is both national in scope and grounded in day-to-day experience. This is the first time we have had the opportunity to appear before this committee since the last federal election. So I want to begin by thanking you for the invitation. I also want to congratulate you, Mr. Miller, on your election as chair, and mention that I look forward to working with you in this new role. Frontline officers are uniquely positioned to speak to the challenges facing our justice system. When Canadians call for help, it's police who respond. It's our members who arrest repeat violent offenders, only to see those same individuals return to the streets weeks, days, and sometimes even only hours later. While it's fair to acknowledge that Canada's justice system generally works well, the persistence of this small but highly disruptive group of offenders places an enormous strain on police resources, heightens risk to officers and communities, and perhaps most importantly, erodes public trust in the system. That erosion of trust is real. Statistics Canada has documented a steady decline in Canadians' confidence in the justice system and the courts. This does not serve anyone well. When citizens lose faith in the fairness and effectiveness of the system, victims feel unheard, communities feel unprotected, and officers feel as though their work does not matter. Confidence is the foundation of legitimacy, and without it, every part of the system suffers. What makes this situation especially frustrating is that both the governing Liberal Party and the official opposition Conservatives acknowledged during the last election that bail and sentencing reform must be a priority. In fact, both parties made specific commitments in response to questions from the Canadian Police Association. As you all know very well, it is rare in Canadian politics to see such broad agreement across party lines, and it would be a profound missed opportunity if Parliament failed to act. Canadians rightly expect progress when their elected officials all recognize the same problem. That is why this committee's work is so important. We hope that your study can move this discussion beyond partisan lines and into the realm of practical solutions. This is not an idealistic or quixotic hope. It is the kind of constructive, evidence-based collaboration that Canadians expect and deserve from their representatives. From our perspective, there are clear and achievable reforms that would help restore confidence and strengthen accountability. Creating a standalone offence for breaching parole conditions to ensure that supervision orders carry real consequences. Mandating the reporting of all breaches by supervising authorities so gaps and delays do not put the public at risk. Replacing automatic statutory release with earned discretionary parole for high-risk repeat offenders, so release is based on rehabilitation, not the calendar. Strengthening reverse onus provisions in bail decisions, particularly for violent and habitual offenders, to better protect communities while awaiting trial. Expanding resources for police to locate and apprehend offenders who breach conditions, ensuring swift and consistent accountability. And finally, increased resources to support any changes that are made in relation to bail and sentencing reform, particularly with respect to additional training and resources for crowns, JPs, and judges to facilities modernization and capacity building within the correction system. These are not radical proposals. They are targeted, evidence-based measures that respect the Charter of Rights and Freedoms while enforcing the fairness and effectiveness of our justice system. Most importantly, they reflect what Canadians expect, that when repeat violent offenders violate the conditions of their release, there are meaningful and immediate consequences. Mr. Chair, our members are doing their jobs. They arrest dangerous offenders and bring them before the courts, but without reforms, the cycle of arrest, released, and reoffending will continue to erode confidence in the system and place unnecessary strain on communities. The Canadian Police Association stands ready to work with all members of Parliament and with our provincial and territorial partners to turn consensus into action. During the question and answer portion of today's meeting, I'd welcome the opportunity to provide more detail on our proposals and discuss how they can be implemented. Thank you.
Thank you, Mr. Stamatakis. Over to you, Mr. Sauvé.
Good afternoon. Thank you for inviting me to appear today. I'm Brian Sauvé. I'm a sergeant in the RCMP and the president of the National Police Federation, the sole certified bargaining agent representing nearly 20,000 members of the RCMP serving communities across Canada and internationally. Our members have varying mandates, including federal enforcement, national security, and in many municipalities and provinces are the police of jurisdiction. They experience firsthand both the successes and the shortcomings of the criminal justice system every day. Tragically, Canadians have seen far too many cases where individuals released on bail have reoffended, sometimes with devastating consequences. These incidents leave deep scars on families, communities, and police officers. They have also shaken the public's confidence in a system that must balance fairness with safety. Now, I want to be clear. Our members believe strongly in the principles of justice, restraint, and fairness that underpin our criminal code and our charter. But they also see the human toll of a system that often functions like a revolving door. Our members are repeatedly arresting the same individuals, often for crimes committed while already on judicial interim release. This is dangerous, demoralizing, and it drains police resources that could be better spent preventing crime. In 2019, Bill C-75 introduced some reforms, codifying principles of restraint and requiring consideration of Indigenous and other vulnerable populations who are disproportionately represented in our justice system. However, 4 years later, municipalities, provinces, and police report that these changes have had little measurable impact on violent repeat offenders or public safety. In 2023, Bill C-48 created new reverse onus provisions for certain violent and firearm-related offenses. These steps respond to some concerns, but they have not addressed deeper systemic issues, such as weak monitoring, inconsistent enforcement, and poor data collection. Canada's criminal justice system also continues to be underfunded, leaving resource gaps that criminals exploit. A disturbing trend our members see is organized criminals recruiting youth to commit serious crimes, knowing that sentencing under the YCJA is far less severe. This places vulnerable young people on a dangerous path and further erodes public confidence. In 2023, the National Police Federation released a report on bail reform. While much of that work focused on what provinces could do to improve monitoring, enforcement, and bail hearing standards, many of those recommendations are relevant to your study today. I'd like to highlight 4 areas where we believe urgent action is needed. First, better data and information sharing. Courts often make bail decisions with incomplete information. National police records are often missing offenses that exist only in local or provincial databases. Judges and prosecutors may not see the full picture of an accused's history. We need standardized, reliable justice system data across all jurisdictions. Without it, risk assessments remain inadequate. Second, improving bail hearing resources and standards. Too often, bail hearings are rushed and presided over by officials without the proper training. We need experienced prosecutors and qualified judicial justices of the peace conducting these hearings with adequate preparation time. Bail decisions are among the most consequential in the justice system, and they must be made with full information and proper expertise. Third, strengthening monitoring and enforcement. Once an individual is released on bail, monitoring varies widely across Canada. Some jurisdictions use electronic monitoring, others have minimal or no supervision. Our members often arrest people who have been released only hours or days earlier and openly ignored their court-imposed conditions. Dedicated bail enforcement resources, including modern technologies and the use of special constables, would relieve pressure on frontline police and provide some accountability. Fourth, addressing youth exploitation. Criminal networks are increasingly recruiting young people to commit violent offenses, knowing the consequences are lighter. Federal and provincial governments must close this gap through targeted prevention, stronger deterrence, and better support for at-risk youth. This is not only about penalties, but it's also about stopping criminal groups from exploiting young people and protecting communities from harm. All of this points to one larger truth. Fixing Canada's justice system cannot be accomplished by Ottawa alone. The federal government writes the criminal code, but provinces administer the courts, and municipalities feel the greatest impact of repeat offenders cycling through the system. Too often, each level of government waits for the other to act, and progress stalls. The path forward requires smart, targeted initiatives developed and implemented collaboratively across jurisdictions. Federal, provincial, territorial, and municipal leaders must work together alongside the police, victims' advocates, and communities. Our members are committed to serving Canadians with professionalism and compassion, but they need a justice system that supports their work rather than undermining it. The National Police Federation stands ready to work with all levels of government to build a bail and sentencing system that truly prioritizes both fairness and community safety. Thank you, Mr. Chair. I welcome your questions.
Thank you, Mr. Soe. For the benefit of members, I'm letting the witnesses complete their statements, even if it goes a little over 5 minutes. We do have, unless there's an objection, but we do have a lot of time today, so I think it's important to hear from them unless someone objects. Mr. Campbell, over to you.
I'm only 3 minutes, so I'll share some of my time over to the other side. So, good afternoon, Chair, Vice Chair, members of the Standing Committee, legislative staff, and other guests. My name is Clayton Campbell. I'm President of the Toronto Police Association. As President, it's my greatest honor to represent more than 8,600 members of the Toronto Police Service, both uniform and civilian. I'm here to advocate for the communities we serve, because there's little difference between what we want and what the public wants, and that is safe and healthy neighborhoods. And despite what some may suggest, I'm here to advocate for fair and balanced justice system. We believe in the Charter of Rights and Freedoms. We believe in rehabilitation. And we believe in second and third chances. Our suggestions for improving the current system is entirely focused on violent offenders who have consistently shown a total disregard for the safety of innocent people. And they are based on the daily lived experiences of our members, the victims they support, and were developed with the help of talented legal minds. I'd like to start with recommendations to the bail system as it relates to sureties. Specifically, we want legislation that defines who presumptively is unsuitable to be a surety. Currently, anyone can take this role and act as the eyes and ears of the justice system, and being responsible for reporting any breaches of the person's release orders. If that person has a criminal record, has previously acted as a surety for someone who has breached their conditions, or if there is a power imbalance between the surety and the accused, these factors should disqualify them for this role. It is unreasonable to expect that someone who relies on the accused for financial support or has been victimized by them should act as their surety. We recommend strengthening the secondary grounds for detention by including a mandatory provision that someone with 2 convictions for serious violent offenses would be ineligible for bail for 10 years, and those with 3 or more convictions would be barred from bail for life. Recognizing that someone with a proven history of serious and violent victimization may have given up their rights to release at the earliest opportunity is not cruel and unusual. We also cannot overlook the role of victims in the bail process, and therefore, we would like to see the rights strengthened to include access to the details of release within 24 hours, and that in certain crimes, victims be provided with a transcript of the bail hearing upon request. Finally, we recommend that bail pending appeal should only be considered where there is a likelihood of success. Since these individuals are no longer accused, but rather convicted of their current crimes, and therefore no longer entitled of the presumption of innocence. Regarding sentencing and parole, we recommend mandatory consecutive periods of parole ineligibility for multiple life sentences, with a release valve in specific circumstances to address the judicial discretion concerns as noted in Bissonnette. We also suggest amendments to the Correction and Conditional Release Act, particularly as it relates to high-risk prisoners. Specifically, we suggest establishing a separate parole regime for the small number of high-risk prisoners. This regime would include, among other measures, lengthening the interval between parole hearings and granting victims full party status at these hearings. Sadly, considering the high rate of youth violence in our city right now, we also need to propose recommendations to strengthen the existing Youth Criminal Justice Act. We believe many of our suggested changes to the adult system should also be implemented for young people. We also request consideration of expanding the allowable periods of both open and closed custody for young people, so that longer sentences can become a viable option in those cases of violent crimes, weapon offenses, human trafficking, robbery, and sexual assault. These suggestions may seem counterintuitive to the core principles of rehabilitation and restraint when it comes to young people. Still, I want to remind you, we are discussing youths as young as 14 years of age who have committed serious violent offenses, not once, but multiple times. In closing, I'd like to emphasize it might be easy to dismiss our stance as biased or politically motivated. However, for us, this is not a matter of politics. It's about public safety. And we have a proven track record of collaborating with anybody from any party who shares our values. At home in Toronto, our mayor is a lifelong member of the NDP. The chair of our police services board is a Liberal. And as you know, we have a Conservative premier. And yet, we've all set aside political differences to do what's right for the safety of Torontonians and our police members. We urge you at the federal level to do the same. We have shared these thoughts and others with Minister Fraser and the Leader of the Opposition, Mr. Pierre Poilievre, in letters dated September 12th of 2025. We'd be happy to make those available upon request. Thank you, and looking forward to any of your questions.
Thank you to all three of you. We're now at the first round of questions as agreed upon beforehand. We have the Conservatives going first for 6 minutes. MP Brock, you'll have the floor. Suivi par la députée Dillon du Parti libéral pour 6 minutes.
And then the Liberal Party for 6 minutes, followed by Mr. Fortin, who will have 6 minutes as well. Mr. Brock, you have the floor.
Merci, Monsieur le Président, et merci.
Expert matters, as I like to call all three of you. Thank you for your attendance. Thank you for coming as quickly as possible. This is an incredibly important study for all of Canada. In my view, it is long overdue. We are just pleased that we're finally launching it. Question to Mr. Campbell to start. The federal gun ban and confiscation scheme is an absolute disaster. Police, academics, licensed gun owners, and everyday taxpayers know that targeting lawful firearm owners won't make Canadians safe. You, sir, are on record saying, quote, "We know that the gun buyback program is going to have essentially zero impact on the crime in Toronto," end of quote. The Public Safety Minister, Gary Andasangari, certainly doesn't seem to think it'll work either. He admitted on a leaked audio recording that legal gun owners aren't causing crime and that police services likely don't have the resources to follow through on the project. Does the Toronto Police Association and your members, sir, believe that the Prime Minister should fire the Minister of Public Safety? Yes or no?
So I don't want to weigh in on who should be fired at this time, but I definitely would want to comment on the gun registry and the impacts on safety in Toronto, if that's possible.
Please.
Yeah, so I mean, the bottom line, the City of Toronto is the gun buyback program would not have any impact on the violence we're seeing in the city. The violence we're seeing in relation to firearm offenses is essentially exclusively to a small number of gang members, thugs using illegal firearms. Most of the time they come across the border. About 90% of the 700 illegal firearms we seized last year came across the border. And most of the time people on bail or are prohibited from using a firearm. And I can say in the City of Toronto, it's a very challenging thing when it comes to funding public safety. And I'm sure if you asked the Mayor of Toronto, Olivia Chow, or Chief Myron Demke of the Toronto Police Services how they could use even a fraction of the $750 million, we'd find a lot of better ways to spend that money to actually improve public safety in our great city.
Okay. I listened very carefully, sir, to the recommendations that you made to the committee in your opening statement. There is, in my view, a lot of similarity to what you are proposing to what our party has been proposing. And in fact, we've introduced a new private members bill called the Jail Not Bail Act, and I believe you were at the press conference a few weeks ago. At the heart of that bill is to replace the so-called principle of restraint under Section 493.1 of the Criminal Code, which essentially states that judges must release the accused at the earliest opportunity on the least restrictive conditions. And practically speaking, that means regardless of what the offense is, regardless of the impact that it has to the community or the victim, regardless of the criminal record, which may establish a pattern of breaching court orders or a pattern of committing the same offense over and over again, and quite frankly, regardless of the number of prior releases the person may be on, that person should be released. At the core of your recommendation, sir, do you believe the principle of restraint has to be rescinded?
Yeah, we do, and we've called for that. And in the end, and I want to repeat, it is not about politics for us, but it's our members having to go see the mother of an 8-year-old just a few weeks ago that was shot and killed while sleeping in his bed beside his mother. One youth's been arrested, 2 are still outstanding. They were both on release using illegal firearms, and so something needs to change. Our members, as my friends here have talked about, are frustrated. They really are doing their best, putting their lives on the line, and something needs to change, and we need to make sure the small number, it's a small number in the City of Toronto, of really violent individuals are not out there wreaking havoc on our streets every day.
For over 4 years, all 3 of you, as well as all other members of the police associations and services, premiers, MLAs, mayors, victim advocacy groups, have been pleading with this Liberal government under the leadership of Justin Trudeau and now under Mark Carney and all the various justice ministers to implement immediate bail reform change to keep Canadians safe. Why, in your opinions, in your collective opinions, I'd like to hear from all 3 of you, in your opinion, why has your pleas fallen on deaf ears by this Liberal government?
I mean, I can start with, I will say, for the first time we did meet with Sean Fraser. We met and we explained exactly the same things I'm saying today, the same information we have provided to the Conservative Party, we've provided to Sean Fraser as well. I don't know. I really don't know. I mean, I say to anybody that's not sure what to do, come on out to a ride-along in the City of Toronto. You see some of the violence going on. You see the victimization. This is not about someone that's made a mistake or some minor criminal offenses. This is just a small number of really violent thugs and criminals that are causing all the problems in the city.
Thank you. I believe the Justice Minister needs to go on a ride-along very, very soon.
We'll take anybody anytime in the
Thank you.
city.
Time's up, and perhaps one of the other members will allow the other 2 to complete their thoughts on this, but we'll turn this now over to the Liberals. Ms. Dillon.
Thank you, Mr. President, and thank you so much to all our witnesses for coming in on such short notice. I think all committee members appreciate that. I'll start with Mr. Sauvé. I very much appreciated your comments and your recommendations. One of those recommendations was that Ottawa cannot do it alone. We pass the laws, we put in programs, and that all levels, provincial, municipal, must also contribute. In your opinion, how can they do better to work with Ottawa as well?
Well, I think it starts with the leadership. One thing that this government can do is provide that leadership. One of the benefits of my particular role is I get to meet with municipalities, large, small, anywhere in Canada. Whether it's the Saskatchewan Urban Municipal Association or the Union of BC Municipalities or the Union of Municipalities of Newfoundland and Labrador, reeves, mayors, elected officials from all communities, large and small. They've all been talking about this. In fact, we're part of a panel at the Federation of Canadian Municipalities earlier this year with Chief Nish from Peel and one of our superintendents of major crime in northern Saskatchewan talking about bail reform. You have willing partners. I will tell you that. You have willing mayors, you have willing provincial leaders who want to get this right. But somebody's got to pick up the ball and start running with it. And that comes from here. And as we mentioned in our opening remarks, this is a shared responsibility. You can change as many laws as you want. But if there are not enough places to put someone in jail before trial, well, what's the judge going to do? Are they going to double bunk? If we don't have enough corrections officers to actually patrol those jails, and keep in mind, police services are recruiting heavily across Canada right now. Corrections, a provincial responsibility, it's a challenging job, and perhaps it doesn't come with the commensurate compensation package that policing does. So I think they're having challenges recruiting enough corrections officers. So all of those resources need to be in place, and someone's got to take the ball and lead with it. And you'll be able to pull your provinces and your municipalities along with you.
And the other thing you mentioned was how important bail is as part of our justice system. And you spoke about the importance of good data in shaping reform. And we're also committed to this evidence-based policy. And what specific types of data collection, such as breach rates, risk assessments, and things like that, would you like to see or recommend as part of that?
Okay, let me give you an example. So I'm a first-time offender. I've been arrested for theft over $5,000, and I'm facing I'm in court. I don't know. This isn't a real example. This is hypothetical, by the way. I'm in court this afternoon at 1 o'clock, and I'm released on bail because I have good character references, first offense, etc. Within the next 3 months before my substantive charge actually gets to trial, perhaps I violate that recognizance 18 times. Could be any one of the things. Could be possession of credit cards. Could be a no-go. Could be consumption of alcohol. Could be any one of those conditions. I violate it 17 times, get arrested 17 times, and I face 17 charges of breach of recognizance in addition to the substantive charge.
Je suis arrêté 18 fois, etc.
What we have seen is that my counsel will negotiate a plea for guilty of perhaps a lesser included offense to that theft under, maybe a theft over down to a theft under, and the breaches will go away. They will be stayed. Now, I move jurisdictions to a different province, and I commit a similar offense. All Crown is going to see is my conviction for theft under or theft over. They will not see those 17 charges of breach of recognizance. So does my bail hearing have the adequate information in front of them to impose adequate conditions? Or would a JJP or a judge that sees that I have a conviction and 17 stays make a different decision on my bail? So that's the sharing of information. Usually those are provincial record systems and they don't share across.
Thank you so much. And if you would share your thoughts, Mr. Stamatakis, on this as well.
I was just going to echo what my colleague said. We've all said the same thing. It is about data collection, information sharing, and also modernizing existing systems where the information can flow from police services to crowns, from province to province. And it's the same information and it flows consistently. We don't have that right now. We don't have effective means of communication between police services who are dealing with these violent repeat offenders every day. We don't have effective information sharing systems between the police and the crowns. And then from province to province, like my colleague has mentioned already, we're not sharing that information. So if offenders are moving, sometimes even within the same province, but if they're moving from province to province, there is no package of information that goes with that offender so that when the file comes to a Crown prosecutor, so that they're aware of it and they can properly prepare for a bail hearing, for example, but it's certainly not before a justice of the peace or a judge who may be adjudicating the bail hearing. So that has to happen, and modernization is a big part of it, and I think this is some of the important work that your committee can do around those issues, and where it gets back to that leadership piece that's already been mentioned, and I think there's a legitimate role for the federal government with respect to that.
Thank you. Thank you.
Mr. Fortin.
Mr. Fortin. Thank you, Mr. Chairman, and thank you, Mr. Stamatakis, Mr. Sauvé, and Mr. Campbell for being with us today. Your experience is precious for the decisions that we will have to make following our meetings. I was listening to what you were saying, Mr. Campbell, concerning recidivists, the repeat offenders, and I was wondering, and Mr. Brock was saying quite rightly that the rule currently is that these people must be freed at the first opportunity. That is to say that they are judged to be not guilty until convicted. So the Crown has to approve that this person presents a danger to society and that there's a risk, flight risk, or that they won't appear. So it's just for the proper administration of justice and to avoid that the person leaves or takes flight, then we would keep the person. But in the example that you gave, there was obviously a problem. Is it a problem that really comes from a poor decision, quite simply? Not to insult the judge who made the decision, but should we consider this a poor decision? Or was there a poor assessment of the accused? How can we examine that example?
There could be some that are, sorry, that's loud. Some that are poor decisions. There could be, as my friend mentioned, a very busy Crown attorney dealing with things. But, we're here talking about amendments to the criminal code, and there clearly is amendments that are needed. And we talked about that we support the Charter of Rights and Freedoms, the presumption of innocence. But when you're talking someone has been convicted or charged with multiple offenses, something needs to change. Someone mentioned the provinces. Obviously, everybody plays a part, but there are clear changes that we've recommended to the criminal code to strengthen that and to try and deal with those small number of violent individuals that are causing all the problems.
Peut-être je me trompe, mais
Perhaps I'm mistaken, but it seems to me with the criteria in effect right now, with multiple repeat offenders, they'd have a good chance of being out on bail. But it's a subject that's very concerning and serious. So I'll change subjects because I don't have a lot of time. In light of all of this, the rehabilitation of the individuals who've been found guilty, how do you see that? Are we not being, are we being foolish to believe this? Is this something we need to work more on?
There is no effective, in my opinion, and based on my experience, and particularly based on feedback I receive from members, we're not effectively rehabilitating anybody. We have, most of our corrections facilities do not have any kind of a therapeutic component to them. Our programming really only starts at the federal level, so if people are incarcerated in provincial facilities, it's very rare that they're going to have access to any of the kind of programming that they would need to be able to come out and be successful. So that's an area that we're really lacking capacity, and again, somewhere where I think the federal government can play a leadership role to build that capacity in provinces. So we are providing, therapeutic capacity in our corrections facilities. So when people who are sentenced or incarcerated, even if it's for a short time, that have serious substance use challenges or mental health issues, they're not just thrown in a jail cell and sitting there. They actually can get access to support and services. So we're not doing a great job in this country, and there's no province, there are a couple of provinces that are rethinking their approach and are having some success, but not enough.
je crois que j'avais 5 minutes.
I have a minute and a half? Okay. Quickly, you spoke earlier about the situation of criminal organizations recruiting young people to commit crimes. And I find that really unacceptable. What do you suggest? Because I thought perhaps naively that we should make the penalty twice as severe if someone incites a youth to commit an auto theft, for example. These should be convicted and sentenced to twice the penalty. So I'd like to have your opinion on that. How do we deal with those situations?
Answer to it all, but I can tell you when you're seeing youth, and you're right, they're being recruited by criminal organizations and gangs to be involved in heavy levels of violence. and only the use are out in a very short amount of time. And I think for those serious violent offenses, firearm offenses, some of the things I mentioned, discharging firearms in the streets of Toronto, they have to be treated as an adult. They need to. And I think the reality of it is that there's many components to it. Stiffer sentences is one, but when you we just had a child, 12 years old, murdered somebody. Yeah, sorry, go
Je ne veux
ahead.
pas vous interrompre, je m'excuse,
Yeah.
M. Kabul, mais
I don't want to interrupt you, but the question is really for the person who recruited that young person, the one who recruited the person. Microphone, please.
Strident regime of sentencing and accountability for the people who are recruiting, and we need to build capacity for those younger kids who are being recruited because of their socioeconomic conditions, because of poverty, because of all these underlying issues. So there has to be sort of a two-pronged approach. Better accountability in the system, more strident sentencing for those people who are taking advantage of young, vulnerable people, and then how do we support those young, vulnerable people so we can get them out of that system, so we don't turn them into chronic violent offenders for the next however many years.
Thank you, Mr. Stamatakis. On avance à la deuxième ronde.
We're moving to the second round.
And then there's four others. There's Mr. Housefather for 5 minutes, Monsieur Fortin pour 2 minutes et demie, and Mr. Lawton for 5, and then back to Mr. Housefather for 5 minutes. So up to you, Roman.
Thank you, Chair. Gentlemen, thank you for your service and thank you for your attendance here today. Mr. Campbell, thank you. I represent the great Toronto riding of York Centre, which is located in the west side of North York. I want to thank the heroes of 31 Division and 32 Division for serving and protecting my constituents. And I want to thank the entire Toronto Police Force for all the remarkable work you do. Mr. Campbell, it seems that almost daily, Torontonians are waking up to hear about another overnight shooting. Almost daily, we hear of gang-related gun violence or targeted shootings on our streets. Now, in 2022, the Liberals passed sentencing reform, Liberal Bill C5, which removed certain mandatory minimum penalties and expanded the availability of conditional sentencing orders. Could you please tell the committee what, if any, effect did the Liberal government's Bill C5 sentencing law had on gang violence in Toronto in the last few years?
I mean, you're seeing people with additional sentences involved in further offenses. And the reality of it is, if someone shoots a firearm in the streets of Toronto, shoots somebody, or is committing major levels of violence, carjackings, kicking someone's door into their house to steal their car keys, they're not going to do it if they're in custody. And I think the reality of it is it's swung to protecting the rights of the accused, and we're forgetting about the victims that are in the streets of Toronto. And, you know, I mentioned we have an NDP mayor, Olivia Chow. She's talking about bail reform. I mean, if we're in the city of Toronto and we're talking that she's talking about this, then things have swung, the pendulum swung that we need to do something about it. So I don't pretend to be a lawyer. There's probably lots of lawyers in the room. I don't pretend to be a lawyer and know every single section and what we need to do. We can follow up with everybody on some of our recommendations, but I know this just as a police officer representing 8,600 people. There needs to be some change when we're seeing people out of custody on conditional sentences with ankle bracelets for shootings and murders, only to continue to victimize the citizens of Toronto.
Thank you, Mr. Save. Thank you, Mr. Campbell. To Mr. Save, you spoke about the need to potentially increase sentencing provisions for young offenders. One thing that really stands out in the last few years is, and particularly within the realm of gang violence, is the prevalence of youth participation. Of course, if a teenager breaks into a vending machine, none of us want them embroiled in a correctional framework. But if a young offender commits a second-degree murder, their custodial sentence under the Youth Courts and Justice Act cannot exceed 4 years. And when you factor pretrial custody time, young offenders convicted of murder are remanded to very little, if any, post-trial custody time. Can you please offer some recommendations with respect to reforming the sentencing provisions of the Youth Criminal Justice Act to help mitigate some of the gun and gang-related violence committed by young offenders?
Well, thankfully, in Canada, we don't see that very often. However, for those situations when we do, I think I'll go back to, we have a rushed system. In order for a file or an accused who's a youth to be considered for trial as an adult, that's challenging on the system that is already overburdened, that has the Jordan Principle to move forward with, and is stretched. So we need to have proper resources allocated to our court system, regardless of the jurisdiction. It doesn't matter if it's Ontario, Quebec, New Brunswick, PEI, Newfoundland, or Nunavut. In order for them to be able to adequately weigh the gravity of the offense, the impact it had on the victims, the impact it's having on the families and the police officers involved, to make that decision to try as an adult, that takes resources. And ultimately, once that decision is made in the proper form, then you'll have sentencing as an adult.
This is a very important point that you made, Mr. Suave, because I believe that the bail reform passed by Liberals, Bill 75, explicitly removed prosecutorial discretion to charge as an adult. And so now our crowns can no longer avail themselves of that possibility. And so do you recommend that we repeal that provision?
I recommend you study it. What the results of that study is, which is why we're here, possibly one solution.
Anthony, you have 5 minutes.
Thank you so much, Mr. Chair, and thank you so much, gentlemen, for being here. Really appreciate it. Who has formerly been a mayor and councillor for a long time. I have indeed done ride-alongs with the Montreal Police, and Mr. Campbell, I'm happy to do one with the TPC the next time I'm in Toronto, and I'll get in touch to arrange that. I know my colleague Vince Casparo just did one recently. So gentlemen, I think this is one where we're wildly in agreement. I think pretty much all of us agree that repeat violent offenders should have a tough time, a very, very tough time getting bail and should not be out on the streets. And we might differ on how we implement this, and we have a lot of problems because nobody takes complete responsibility. You have the federal government that's responsible for the criminal code. You have the provinces that are responsible for the administration of justice, police and crown prosecutors, court resources, judges and justice of the peace, jails and jail guards, and everybody blames everybody else when things don't work.
On a un problème d'interprétation.
We have a problem with interpretation. Just a moment, please.
Aucune traduction, regarde. Zéro. D'audio. Ouais. Ouais, vas-y.
Monsieur Housefather, si vous pourriez débrancher.
Mr. Housefather, if you could disconnect your microphone and then plug it back in again, your headset, that might make the difference. I'll try.
Peux-tu fermer mon micro, s'il te plaît? On pourrait reprendre notre test sonore qu'on a fait tantôt.
We'll try the test that we had done earlier. Thank you, Jean-François. Is it working now? I can see on my screen that I'm using the Jabra, which is correct, and I'm connected properly now. That seems to be have fixed it. Thank you. Okay, thank you. So can I begin again?
Mr. Chair, can I go?
Oui, il vous reste 4 minutes, Monsieur Housefather.
You have 4 minutes left.
So, gentlemen, I'm going to move to my questions. The first thing that I want to ask you about is C-48, where we reversed the onus of proof with respect to various violent offenders. Can I ask you, let's start with Mr. Sauvé, how has that changed things? Has that improved things? And should we then use that mechanism for other types of violent offenders?
Very quickly, I think I've been quoted widely as saying it was a good start.
No, but
more to do.
How would what would be the next step?
So go ahead.
So as a good start just means you've started. And you know, I've said a number of times, and I think I've said it here today, I'm happy to see that you guys are all working together and everybody's moving forward in the same direction to accomplish the same goal, which is safe streets, safe communities, safe police officers, and safe Canadians. So if that means continued expansion of reverse onus provisions as far as a recommendation, fantastic. Then the provinces and the territories who administer that justice system need the guidance and the leadership and the resources to be able to do that. We can't just have laws that say we're keeping people in jail and not have places to put them. We can't have laws that say judges must do this, but then we don't give them the resources to be able to accomplish that in a timely manner. We can't just say that we're going in this direction, and our police officers will do that. They will enforce what you put in place, but then all of a sudden the subsidiaries or the corollaries or all of those downstream impacts fall off the rails, and then you're back where you first started. So that's what I would recommend. Sorry, it was a little longer than it was a good start.
But that's
Agreed. That was a good start of the answer. Mr. Stamatakis?
We're on the record of supporting some of what you alluded to in C-48 and expanding around reverse onus provisions. But I will say it's made no difference because of the thing that Mr. Sauvé alluded to and mentioned in his opening remarks. And this is what I urge the committee to, one of the areas I urge you to focus on is how do we get, once you create the laws, how do we create the environment where everybody works together, all levels of government work together to then implement? Because I can give you examples of, post C-48 and the reverse onus provisions where in British Columbia, for example, people who should have been subject to those reverse onus provisions were being released on bail. And it ties back into what my colleague mentioned about resources and capacity and all of those kinds of things. So part of what needs to come out of this exercise, in my opinion, is some clear recommendations around how, if there are changes, amendments to the legislation, how can they be implemented in a more effective way and followed through on more effectively by the provinces?
That makes complete sense. Could I mention that I think that one of the things that would make a lot of sense is that once federal legislation is adopted and on the process to it being adopted, you would then have a federal, provincial, territorial meeting with the FCM, with the Conference of Mayors, with police chiefs, and bring everybody together at the table to talk about how it will be implemented, as opposed to the federal government just saying, we did our job, now you go do it, and vice versa. Would that make sense to you, Mr. Stamatakis?
Will be implemented and specific commitments around following through. 100%, I agree with that.
Mr. Sauvé, agreed?
Agreed, and I'm surprised it already hasn't happened. Everybody's been talking about it for 3 years, and all of a sudden no one's been in the room taking a leadership role and saying, let's try and get this ball across the finish line. So 100% agree with it.
And Mr. Campbell? I didn't give you a chance to speak to this, so do you have anything to add?
Let Mr. Campbell complete his thoughts, but the time's up for now, Anthony. And
oh, sorry, Mark.
No, no worries. On a 2 minutes et demie pour M. Fortin.
Okay, 2.5 minutes for Mr. Fortin. Thank you, Mr. Chairman. In 2.5 minutes, I'll go quickly. I noted earlier that when you said that there's a lack of communication between police services, between municipal, provincial, and federal services. And so we find ourselves dealing with problems in different provinces, and it hasn't really been taken into account. And as we're studying this bail review, so I'm thinking that a common register would perhaps be useful. And I think that's a bit what you were saying earlier. My question is, in the same line, we had proposed a few years back the creation of a register for criminal organizations, and you know that there is a register for terrorist organizations, and all terrorist organizations that are listed in that have consequences that they have to face, and I'm not going to go through it, it would take too long, but would such a list, criminal organizations such as the Hells Angels or others who commit crimes, would that be useful, in your opinion, in this fight against crime, particularly when we talk about the recruitment of youth? And we could say those listed organizations are criminal, and we would automatically say that they would be subject to these new rules. What is your opinion on that?
But there's better ways to do it. So, for example, if we're going to modernize law enforcement, national security, and information sharing systems in Canada, let's do it once, right? So it's challenging already with different police services across Canada using different systems on the street. And you saw it come out in the Mass Casualty Commission where the Halifax Regional Police is using VersaTerm, the Halifax RCMP is using PROS. They don't communicate each other. You actually have to pick up the phone and talk to them. So if we're going to talk about information sharing in Canada from a law enforcement perspective, then let's go with one system. And, you know, we already have a CPIC system which works quite well, but could use a serious injection of technology to bring it to 2026 instead of 1986. And that can be your law enforcement system. All police agencies have access to it. It is sequestered for national security files as well as put off anti-corruption investigations and such in different areas. So you can use that system, and it would be easy enough to have a Crown in Prince Rupert access that system just like a Crown in Fort Saskatchewan, Alberta.
Mr. Lawton, the floor is yours, 5 minutes.
Thank you very much to all of you gentlemen for being here and also for your service. It's very much appreciated. Mr. Campbell, has Public Safety Minister Gary Nandasangri ever consulted with you on the firearms buyback?
Yeah, so we met with the Public Safety Minister, we met with Sean Fraser, the Attorney General, and we spoke the same things that we've talked about here today. We've communicated to everybody equally.
Mr. Sauvé, have you spoken with the Public Safety Minister about the gun buyback?
We've been in conversation and getting updated from the Commissioner of the RCMP just as to how it may impact our members.
But in the development of it, were you consulted for the effect it would have on your members and your members' willingness to participate in it?
We were not, no.
Okay. Mr. Stamatakis, same question to you. Were you consulted in the development of the buyback by Minister Nandasangri?
Well, we provided feedback when that program was first developed, so that was before the current minute. Oh, sorry.
Relevance. I don't think the question is relevant to the study.
Chair, I would say that the firearms policy in this country, when all witnesses have spoken about the expanse of gun crime and the priorities of this government in dealing with it, are highly relevant. So I actually think it's quite short-sighted for the member to suggest that going after legal gun owners is not relevant to a study on crime and bail and repeat offenders when firearms have been mentioned by our witnesses.
Yeah, it's a stretch, but keep it a little tighter, Mr. Lawton. I understand where you're going, but just afford the witnesses the opportunity to answer to it. And
I will.
Perhaps stick closer to the theme of the study.
So my Liberal colleague actually raises an important point here, which is that law-abiding gun owners have nothing to do with crime. So I'll ask you, Mr. Campbell, because you have spoken about that in the past. Do you believe that law-abiding firearms owners in Toronto are a public safety risk?
No, and we've talked about this before. The gun buyback program is going to have zero impact on the crime we're seeing in the city of Toronto, period. And quite frankly, I don't know if there's any plan in place, but if there was some sort of plan to try and obtain these firearms, I'm not sure who's going to do it or what resources, and I can think of 100 different ways, if you want to help public safety in the city of Toronto, that we could have other things to do.
And Mr. Stamatakis, I'll ask the question to you as well, because we have heard repeatedly when we've been speaking to police officers and police chiefs that they do not have the resources to keep up with existing criminality on the street. Police lack the resources to check on bail conditions. And I'm wondering if you can speak to that first and foremost. How are police forces with scarce resources dealing with the amount of time it takes to just check up on people on bail?
They're not. We don't have the resources, and we don't have the capacity to target repeat violent offenders that are released on bail to the extent that we should be. So you have to prioritize. You prioritize based on how prolific the violent offender is and what resources you have available. And so back to the buyback program, I agree with my colleague. You know, there's a lot of resource challenges, and there are things that we could be using those funds for that would be more effective than a buyback program that, to be blunt about it, police services in Canada don't have the capacity to try and manage.
Mr. Sauvé, do RCMP members want anything to do with having to go around and collect firearms from law-abiding gun owners?
I haven't spoken to RCMP members about collecting firearms. You know, we are on record back when C-21 was tabled that, you know, the appropriate use of resources to have an impact on crime in Canada is to target illegal firearms trafficking coming up from the States. And if any government were to take any resources and put them into greater border enforcement, guns and gangs units with municipal or provincial police services, you would see a market impact on gun crime in Canada.
Thank you. Mr. Sauvé, you said earlier that the federal government can provide leadership. Do you see that leadership from this federal Liberal government on these bail issues?
Well, we're sitting here, and I think this is a great thing. You know, I've heard that there are numerous pieces of legislation that are coming forward that are going to touch on different aspects of law enforcement, immigration, border security, bail, all of those things. That encourages me. I think that it should encourage Canadians that these difficult discussions that Canadians have been asking for are actually happening.
I'll ask a question to you, Mr. Campbell. There was a situation in St. Thomas, Ontario, where a homeless man, a repeat offender, was released on bail with a curfew. He had a condition that he had to be in his home at 10 p.m. Is that something that's happened in Toronto, an unenforceable bail condition?
And I'll agree with Tom that there is not the capacity to take a look at these people out on bail and actually try to enforce it. I know the province of Ontario is a recommendation here to look at. It's an app. There's a lot of young police officers. It's essentially like MLS. If you're looking for real estate, but for bad guys out on bail, it's something that's in the province of Ontario. Talking about information sharing, that is something that could be implemented Canada-wide that could help us if we had the capacity to actually track these bad guys.
Countered bail conditions that are unenforceable.
Mr. Lawton, your time's up. Okay.
Thank you.
Over to Mr. Housefather for 5 minutes.
Okay, thanks very much, Mr. Chair. Gentlemen, one of the things that I hear the most often from like frontline officers who have to go to bail court is a frustration with the amount of times that there's a consent release, which is where I believe it's where the Crown essentially agrees to a release plan without this being heard before a judge. Would you consider that to be an issue, that there are too many consent releases? And if so, yes, I know more resources is one of the remedies. Can you just tell me what you think about that and whether that's something we should be looking at?
I can speak in Toronto, absolutely. Our members don't have the time or resources to go to all these bail hearings and actually advocate sometimes to keep people in custody. If we had the resources to do that, they would 100% be there and be providing more information to the Crown to hopefully help them make the right decision to oppose bail.
Ironically, the requirement to have police officers participate in bail hearings was essentially as a result of downloading because of resource challenges with the Crown. So it was downloaded to the police who don't have the capacity to begin with. So 100% this should be an area of focus. I think we've all alluded to it at different times. We need better information available to the decision makers when it comes to bail release or any other type of release regime so that they're making informed decisions. And one source of good information are the police who are interacting with these violent repeat offenders every day, sometimes often multiple times a day. But also, there's got to be a mechanism where we can include victims in this conversation, particularly for those violent repeat offenders, because what they're doing in our communities, and it's not just Toronto, it's not just the big cities across Canada anymore. It's the big cities, it's the towns, it's the villages, you know, north to south, south to north, east to west, right across the country. And the impact of their violence on Canadians is having a significant impact.
Mr. Sauvé, anything on that?
I don't think anything I can add. These two guys covered it off pretty well.
Yeah, I agree. This is a really important issue to focus on. We need more contested hearings, and we need to have more information at these hearings before people are just released with conditions. One of the things that I wanted to ask about is, if I may be wrong, but in certain provinces, and I think Ontario, where you guys would be more familiar, is one of them, a justice of the peace does not have to have a legal background. Is that something that should change? Should the justice of the peace be required to have a legal background and to be more, at least have a better understanding of perhaps the criminal law?
I can touch on that. I don't necessarily think that JJPs or whoever is conducting that hearing has to have a legal background. But, for example, all police officers have a considerate equivalent training across Canada, whether it's in use of force, whether it's in knowledge of the law, whether it's all of those great things, provincial or federal statutes. Why doesn't our provincial justice system have a consistent standard? It's the enforcement of bail, or the decisions on bail hearings, or how they present a bail hearing. Nova Scotia is different than Ontario, it's different than British Columbia, it's different than Alberta, it's different than Nunavut. Some cases, our members are the Crown. And that has been left to them, because in a lot of situations, I mean, I was in Wati, Northwest Territories a little while ago, and we are the only representative of the government in that particular small town. So that training should be available to them to meet that standard, but that standard doesn't exist across Canada. Hence, every province does it differently. So legal training, I don't know, but a consistent level would be appreciated.
Thanks very much. Mr. Chair, do I have any time left?
Get off a quick question, Anthony, and there's 40 seconds left.
Okay. Basically, one last question. Youth exploitation, recruiting young people. Mr. Fortin had suggested a double sentence or a sentence of twice the duration. Do you guys have any good suggestions briefly on what the right way to do to deter in that instance is?
I mean, I agree sentencing has to be looked at when you're seeing, and they're gang members, organized crime members recruiting youths as young as, you're saying, 13, 14 years of age to be involved in this level of violence. I think there should be increased consequences for these individuals.
You could build some
Thanks very much.
reverse onus provisions, for example, if you identify a person engaged in that behavior.
Okay, thank you.
Thanks very much, all of you.
Thank you, gentlemen. We're on to the third round. We'll be led off by MP Shipley for 5 minutes. Then back again to Mme Deline, 5 minutes. Réal Fortin, 2 minutes et demie. Andrew Lawton for another 5 minutes, and then Wade Chang for 5. Huh?
No.
No. 2 et demi.
2.5 minutes. We'll
Faire la mathématique.
we'll do the math.
Pour moi, c'est
Mr. Fortin's comment was inaudible.
Trêve de bavardage.
Mr. Shipley, you have the floor.
Thank you, Chair, and thank you to the witnesses for being here today. I had a nice list of questions here that I was prepared to ask, but Mr. Campbell, you said something that really piqued my interest, and I want to get into this a little bit with you because I've been thinking about this for a while now. You mentioned that the justice system seems to have leaned more towards, and I'd like all three, please, to weigh in on this, is now leaning more towards the rights of the accused than the victims, and I scribbled that down as you were speaking that. I think I pretty much quoted you there. I was recently present at a swearing in of 3 Justice of the Peaces in Toronto, and there was many speeches that night, not just from the new JPs coming in, but from some senior judiciary, some management, some really a cross-section of people. And I left that event a little bit perplexed, quite frankly, because in all the speeches I heard that night, all I heard was that everybody was there to protect the accused. The word victim was never spoken once. And I left that, and I said it, I was actually with my wife, and I drove home, and I said, did you hear that? And she had agreed. Not once did anybody mention that they were there to protect the victims. Could you maybe expand on what you were talking about, Mr. Campbell, and have you really felt the judicial justice system has leaned that much? And I'm sorry, I'd like all the gentlemen to comment on this and explain maybe what's really going on in the courts.
Yeah, and some of our recommendations, if it's around parole, we have some recommendations there, some parole hearings for those really high-risk offenders, talking about victims' rights to making sure they understand when someone's released. But I think it's a big difference when our members, the ones I represent, are out there seeing this extreme level of victimization. It's not something you're reading on a piece of paper. You're seeing someone shot and killed. You're seeing a child raped. You're seeing that 8-year-old that I keep coming back to shot in his bed at 8 o'clock in the morning, and it's our members that have to deal with these people. It's our community officers that have to go back into those communities and try to build relationships. And it just seems like it's always focused on the offender. And I get there's every person has rights, and there's presumption of innocence, but we need to put victims first. And I think Canadians are fed up with it. Even in the city of Toronto, they want to see consequences, real consequences for these small number of individuals causing the violence in our streets.
What they also want is relief, because the repeat violent offenders, that small number of people that are chronically committing these crimes, are effectively terrorizing citizens in these communities. And they want relief from that. And even worse than the actual crimes themselves is this atmosphere of an unsafe environment that it's created for citizens that are just going about their daily lives. So that's why we all emphasize an opportunity for, weighing, and it gets back to making sure that people who are making decisions around release, whether it's bail or parole, they have all the information available. There's some things happening in our parole system right now that everybody should be worried about. We're getting to a place where parole boards are talking about making decisions about releasing murderers without hearing from victims or the affected families of victims. So to me, this is a problem, and we need to rethink that.
I'll make it quick, but I'd urge you to consider why victim impact statements are only received post-conviction. Why not pre-conviction and during a bail hearing? Having an accused of domestic or intimate partner violence, not hearing from the victim and at a bail hearing, how big of an impact is that going to have on that victim should they be released on bail?
Thank you. I've got very little time left, but I would like to expand on this issue. You've all mentioned kind of that it sounds like we've got agreement this is going on. Can anybody pin down to why this is happening and when do you think, all you gentlemen have been around law enforcement for a long time, when did you start to see this switch? Because it hasn't always been there, and why?
Yeah, go ahead, Tom.
In my experience, what I would say is we've gotten away from holding people accountable and expecting individuals to take responsibility for their actions. And and I can get into a long story about why I think that's all happened, but I think when we shifted away from that notion of holding people accountable and expecting people to be responsible for what they do, making excuses for them, and attributing what they're doing to all the underlying issues, that's where we lost our way, and that's where I think the voice of the victim and the average community member who's just trying to live their lives in the community got lost.
I'll add quickly.
I'm sorry, we have to move on to the next.
Gotta be very, very quick.
I just don't want to cut in. I'm letting you guys finish your thoughts, and if these guys can fire a question off within the time period, then we're allowing some. What's that?
You submit it in writing to us if you had something to add?
Absolutely, you could submit it in writing, or another member. We have a lot of time left until 5:30, so another member could capture that. I'm just trying to allow our witnesses to finish their thoughts, and I will cut people off if they're members off if they're talking past their time. But I think for these guys, it's important to finish it off. But I don't want to go on too long because it looks like favoritism. MP Dillon, you got 5 minutes.
Perfect. Thank you so much. So I will continue with Mr. Sauvé. You were mentioning that it's important for bail decision makers to have a legal background. Could you please explain, go into detail why you think it's important?
Not necessarily. So my perspective is not that they have a legal background, but that the training across the country be consistent. If that means some form of a legal background, okay, that's for the decision makers to come up with. But there needs to be consistent training in every jurisdiction across the country, and right now it's a hodgepodge.
And so provinces such as Manitoba, they've launched or expanded electronic monitoring for high-risk accused. What lessons should we inform any future federal provincial work tools? So this is targeted effectively in the same manner, because you did mention just previously during one of your responses that there is a hodgepodge. Different provinces are doing different things. So using Manitoba as an example, would you be able to elaborate, please?
The province of Manitoba is actually being pretty innovative. They have been, and I thank the Premier for actually going down that road and doing difficult things in difficult times. The electronic monitoring is interesting. It doesn't work in all scenarios, especially in Canada, where our 5G network is not necessarily as adequate as it could be. I mean, if we're talking about the James Smith Cree First Nation, maybe electronic monitoring is not great, but in the city of Regina, it might be. The Lower Mainland of Vancouver, it might be. I think there's opportunities to leverage 2025 or even going into 2027 technology. Does an electronic monitoring bracelet actually need a response by police should it set off an alarm and be outside of range? Or can that just go automatically to Crown and issue a warrant for arrest? The next police officer that comes across that person puts them in cuffs and sends them back. So there are things that we can do that don't necessarily burden the frontline police officers if we're going to think about that.
Thank you so much. And Mr. Stamatakis, I have two questions for you. You said that provinces are starting to rethink the way they provide corrections. Which provinces and what programs are they providing? I think you can pick on Mr. Sauvé, what he said.
First of all, I think technology is part of the answer. I think that's the future, is we need to find ways to use technology to better assist the police, but also communities in terms of keeping them safer. In terms of what provinces are doing things differently, I think Alberta is probably the leader in terms of rethinking their approach, where they're attaching therapeutic capacity to their corrections facilities, so that when they get someone into that facility and they're incarcerated for whatever reason, if there's an underlying drug addiction issue or a mental health issue, they're actually being moved into the therapeutic wing of the corrections facility where they can get support and treatment, and even potentially training opportunities, whatever. That's how we disrupt the cycle of this constant offending. If all we do is arrest people, incarcerate them, and do nothing, you're just kicking the problem down the road. You're going to release the person, they're going to come back, they're going to reoffend, they're likely going to reoffend.
About rehabilitative measures, yes. And I agree with you. I think everybody here does, because just putting somebody back out without resolving the underlying issues is also important. So I appreciate you saying that as well. And we're seeing,
though, right?
Yes, of
because
course.
we can't.
Yes.
Because also incarcerating disrupts the disorder and the crime. So it's
Absolutely.
both. Yeah.
Yes, that's a global picture of everything. And the second question I have is, can you also talk about Crown resources? Many of the witnesses have said they don't have enough time to prepare for trials. Could you talk to us a little bit about this, what you've observed?
It's a chronic problem. I mean, I've certainly experienced it personally as a police witness on a file where you're just waiting. You may get an interview before the hearing, you may not. And that's something we hear consistently from our members all the time. It's a chronic issue. We're here advocating on behalf of our members, but look, this is also a Crown resource, public prosecution resource issue as well. They need more capacity, they need better tools. We need to modernize their systems as well, so there's better capacity to exchange information, share information, so that everybody in the process is making an informed decision.
Oh, okay. Thank
Mr.
you.
Fortin, la parole est à vous, 2 minutes et demie.
Mr. Fortin, you have the floor for 2.5 minutes. Thank you, Mr. Chairman. I've come back to the issue of criminal organizations. I understand that you said there are other ways of doing this. Tell me, when you want to charge someone or give evidence that someone is a member of a criminal organization, am I correct to say that this is a laborious case? You have to, first of all, establish that the organization in question really is a criminal one, and then you have to prove that the person is a member of the organization and that then they committed a crime to the benefit of the organization. So in that sense, if it's good to for fighting against terrorist organizations, it must also be to fight against criminal organizations, because with all due respect, those organizations do more harm on the front lines here in Canada than international terrorist organizations. The harm that Hell's Angels cause here in Canada, and if we can fight those other terrorist organizations with such a register, it's a long question. I'm sorry, I only have 2.5 minutes. But Mr. Sauvé, we heard you on that. Perhaps Mr. Stamatakis, you could say what you think. If it's not a register that's needed to be more efficient fighting against organizations, what is it?
I'd echo Mr. Sauvé's comments earlier. We have systems in place right now. I agree with you that creating a record around a criminal organization's activity or the activity of an individual who's engaged in gang crime, organized crime, is important and a very useful tool. But let's not build a whole new system. Let's use the existing system. We have CPIC. With the right kind of investment, you can expand.
Mais vous n'avez pas de registre d'organisation criminelle.
But we don't have this kind of organization. It exists for terrorist organizations, but not for criminal organizations. So don't you think we should use that tool? Because it can take up to a week or two of hearings just to prove that the Hells Angels truly is a criminal organization and not just a motorcycle club. So is that not important for you?
There's always going to be a challenge building the case, gathering the evidence, putting it together in a comprehensive file that can be successfully prosecuted. But I guess we're talking about resources, and I don't let it's a question of how do you most efficiently use the dollars that are available, and do we build a whole nother system, or do we find a way to use the existing systems and add to them to make them more efficient and more effective? I agree with what you're suggesting. I just would hate to see us try and build a whole new system to capture that in Canada, because it's different to capture that than it is to capture organizations engaged in terrorism.
Je m'excuse, je ne vais pas être impoli.
I'm sorry, I don't want to interrupt you. Oh, my time is... I'm sorry. You had finished. Sorry.
Thank you very much. So the Liberal Bill C-75, which enshrined in the criminal code the so-called principle of restraint, that offenders have to be released at the earliest opportunity under the least onerous conditions. That went into effect a little over 6 years ago. That bill was passed. How soon after that, Mr. Stamatakis, did you start to see the effects of increased bail on less onerous conditions?
Yeah, I don't know if I can... I mean, this was an issue already, and I think the effects arguably were felt immediately, almost immediately, because for all the reasons that we've described, and I don't want to repeat them, but we do, what I would say is we need almost like a bifurcated system where I actually don't have an issue with the principle of restraint or the concept in C-75 when it comes to, a first-time offender with no history. But what we need to do is we need to find a way to treat the violent repeat offender differently.
For sure, but you're saying you can draw a direct line from that provision to these bail problems on the streets that your officers have to deal with.
Well, I think it's a little more complicated than that, because we also have an underlying problem in this country with drug addiction, substance abuse. We have a huge problem in this country with a lack of support for people suffering from mental health issues. But in my view, anecdotally, based on feedback from members, experiences that I've had in my own community where I live, there's a correlation.
I'll ask you, Mr. Campbell, on that drug question. When your officers encounter someone who's using drugs in public, you're laying a charge. What are federal prosecutors doing with those charges on simple possession?
Who's laying a charge for simple possession?
So
in this
let
country.
me ask you, what do your officers do in a case like that, and why?
Most of the time, they're not doing anything. They move on to something
Sorry,
else.
your mic was off. I'll ask the
Sorry.
question again and get you to repeat it. So when your officers come across open drug use in public, what are they doing and why?
Yeah, a lot of the times, my mic's on now, a lot of the times they're just seizing it for distraction. They may not go down the road of actually laying a charge. If it was, you'd see it withdrawn. If it's a resource issue with the federal prosecutors, I don't know, but that's generally what happens in the city right now.
And these drug charges, just for those unaware, these are federal prosecutors, the Federal Public Prosecution Service of Canada that's responsible for that.
Yeah, if you want to go again for a ride along, you can come down into 51 Division, which is down at Regent Park, and you can see open drug use every day right in front of you. If anybody wants to come take a look at it.
So we've been talking about bail, but we're not even at the bail stage here because the federal prosecutors are deciding to not enforce the law effectively, to not apply the law.
I wouldn't want to guess on that. I can definitely get back to you with more information. I'm not sure if any of my friends would have more information on that.
I can say that was the case when I started my career over 20 years ago. The simple possession, Tom says it jokingly, but yes, in the lower mainland of Vancouver, we did not arrest for simple possession of Vancouver, and that's 20 years of experience there.
All of you have spoken to some degree about officers arresting people, rearresting them days, sometimes hours later. When an officer makes an arrest, my understanding is there's a risk. There's a legal risk, there's a physical risk that could go sideways. And I have heard anecdotally, but I was hoping you could shed some light on it, one of you, from officers, that there's a temptation to not expose yourself to that risk when you know that they're going to be out on bail and it will all be for nothing. So how does that affect morale of officers when they're seeing these people that they know on a first-name basis on the street, regardless of having been arrested for a very serious offense?
Yeah, I can say it impacts morale greatly. Our members in Toronto are doing their part, and they literally are risking their lives. We've seen a few years ago, we had 8 police officers, I think I'm right, Tom, killed in the line of duty in Canada. They're risking their lives to make these arrests. I'm proud of them because they still go out there every day and do their job because they care about their communities. They care about victims. But it's tough. It definitely impacts morale when you do say our gang unit does a complicated investigation, takes a long time. Lots of work, lots of resources, only to see those gang members back out of custody in a matter of days.
We have some emerging research in Canada recently, and Quebec's sort of leading the way, where it's more troubling than that. It's not only demoralizing, but we're creating an environment where police officers are disengaging. They're not taking those risks. They're not being proactive in intervening when they could be because of the futility of it. It's creating a lot of challenges in our sector from a wellness, mental health, moral injury perspective.
Mr. Lawton, time. Thank you. MB Chang.
Yeah, thank you, gentlemen, for being here. I represent the great people of Burnaby Central in BC, but I will start with Mr. Campbell. For those who may be watching from home, they might not fully understand how the bail system works here in Canada. The federal government is responsible for the criminal code, and the provinces are responsible for the administration of justice, including policing, crown prosecutors, court resources, judges, justice of the peace, jail, and jail guards. Is that correct?
Yes, that's my understanding.
Okay. When we hear in the media that someone was not out on bail when they were charged, again, the public is not informed if that person was released with the consent of the Crown Attorney. Do you think there should be?
Can you repeat that? I apologize.
Pardon?
Can you repeat that?
Okay.
I apologize.
When we hear in the media that someone was out on bail when they were charged again, the public is not informed if that person was released with the consent of the Crown Attorney. Do you think they should be?
That the public knows what's happened with the Crown Attorney? That they released, they consented?
Whether or not
sure. Transparency is important, yeah.
Okay. So I will turn to Mr. Sauvé. In your public statement, you emphasize that bail reform alone isn't enough and call for data-driven, evidence-based measures. As a government, we have been committed to that approach. What additional support, like mental health services, community-based interventions, would most reduce reoffending while protecting our communities here?
Well, I think my colleague Tom here has touched on it, so has Clayton. We've talked publicly in different forums about the public safety continuum. It's not just policing. It's not just jail. It's not just corrections. It's not just parole, probation, Crown attorneys, judges, but it's homelessness. It's addictions. It's vocational training. And in the provincial system, there is very little of all of the vocational training, addictions treatment. So your sentence is 2 years less a day because, great, it's a provincial sentence, not federal time. And all of a sudden, you're going to be out in 6 months, 9 months on parole, but you haven't had treatment. You don't have a place to live. Nobody's trained you for a new job. And what are you going to do? And then there's also the issue of what our members see is the regionalization of services in the provinces has become a challenge. So, for example, Wati, Northwest Territories, is 3.5 hours away from Yellowknife. If I am to appear in provincial court in Northwest Territories, I'm going to be going to Yellowknife. So I'm going to get picked up, maybe I get remanded, I'm sent down to Yellowknife, but perhaps I get released on bail. Does the system give me a bus ticket back to my home community of Wati, or do I have to hitchhike? Have we put the offender just from the regionalization of our systems? The same thing happens in Prince George. The same thing happens in Fort Nelson, Fort St. John. Just from the regionalization of our systems, have we put those offenders at greater risk of reoffending?
Can I just add?
Yeah, of course.
We've allowed a narrative to become entrenched in this country over the last number of years where it's an either or. If we just arrest and incarcerate, that's bad. It has to be rehabilitation only, and we have to get to the underlying systemic issues that contribute to the crime. That's led to something that somebody else asked in one of the questions in terms of what's changed. We need to get back to both. It has to be both. We have to be able to, like people say all the time, we can't arrest our way out of this problem. I actually say we can. We can arrest because then we can connect people to services. We can do other things. Arrest shouldn't just mean incarceration. So the problem is we've focused on one or the other. It's either or. What we need is both, right?
Thank you, gentlemen. Do I still have time?
Another minute, wait.
Yeah. So, Mr. Sauvé, Bill C-48 strengthened reverse honors on intimate partner violence and firearm offenses, two areas that police and victim advocates identify as priorities. From the RCMP's perspective, how have these changes improved the safety of victims and officers on the front lines?
I don't think they have. And I think the more that any government can focus on firearms offenses or firearms-related offenses, as well as intimate partner violence, domestic and intimate partner violence, the more Canadians will feel safe. And the more focus you put on that, the more the provinces will pay attention, the more Crown attorneys will pay attention, the more judges will pay attention, and we will get to a world where it is not okay to do any of those things.
Thank you, Mr. Chang. The time is up. Members, we have time, if we keep it tight, to do another full round. It'll be led off by MP Baber for 5 minutes, then MP Saini for 5 as well. Monsieur Fortin, ensuite 2 minutes et demie.
Then Mr. Fortin for 2.5 minutes. Mr. Brock for 5 minutes, followed by Mr. Chang, and that should bring us right to 5:30. So let's start now with
One of the big fails of Liberal Bill C-75 is that it created a diversionary regime for offenses involving failures to comply with court orders. So offenses such as failure to appear or breach of an undertaking and even breach of a bail condition may go unpunished. Basically, Bill C-75 allows the Crown to divert or remove such cases from the docket. Crowns may be too busy, and they may be tempted to let these violations go. Would you agree that this diversionary regime contributed to additional crime and contributes to additional crime? And what message does it send? Does it undermine the administration of justice in your view?
That's a hard question to answer, especially within your 4 minutes, 5 minutes. But as my colleague Tom spoke to earlier, the trends are not new. We've seen conditional release be on the upswing, especially during my service. And, you know, I'd recommend a couple of witnesses for you. Like Amanda Butler is a fantastic PhD criminologist out of Simon Fraser University. She and retired Chief Doug Lepard did a study for the province of British Columbia about basically random stranger violence in the streets of Vancouver in 2021. What they found, and we are all creatures of habit, was that during the COVID pandemic, JJPs and judges were reticent to deny bail for even the most violent offenses because of overpopulation or the creation of super spreader cells within pretrial custody jails. That trend has continued post-COVID, post-vaccination, because we become creatures of habit. So is it just Bill C-75, or is it societal in nature?
Thank you. I was specifically asking about those type of diversions, but I want to move to Mr. Campbell. Mr. Campbell, I want to, first of all, pay tribute and send all my love to the family of Carolina Hubner Makurat, a 44-year-old mother of two who was killed when she was struck by a stray bullet outside of a drug consumption site in Leslieville. Yesterday, a drug dealer who sold fentanyl outside of that drug consumption site pleaded guilty to manslaughter. This was a 22-year-old man who admitted participating in a robbery that resulted in Carolina's killing. We all remember that tragic case. Liberal drug policies are putting Canadians at risk. They don't just perpetuate addiction, but also attract crime, trafficking, and other criminal activity. We also remember the testimony of London's chief of police, who indicated that much of the safe supply is often diverted and is sold on the street for profit or often deadlier drugs. Would you agree with me that the liberal drug policies, and specifically the drug injection sites that Pierre Poilievre correctly refers to as drug dens, increase crime and violence on our streets?
They absolutely do. We could follow up with the data on that. They're a mess. If anybody's been around them, they're a disaster. The people that have to live close to them, I feel sorry for them. It's horrible. There's people, we talk about openly using drugs right on the street right now. I could take you to any number of them.
And of course, that attracts trafficking and violent crime, and just like in Carolina's case, a robbery. I'll take this opportunity to take you to a local Toronto issue, in that, as you may know, that Toronto's homeless shelters now effectively function as satellite drug injection sites. Is that correct?
Absolutely. Unfortunately, near one of our office, I can see it from my office window.
And so right now, the City of Toronto is proposing an additional 20 shelters where anybody can come in and get drug paraphernalia and needles. One of them is proposed for my riding at Keelan Wilson, and the other 19 also in residential neighborhoods. They're asking the federal government to pay for such construction. And this is in Caledonia and Eglinton, Keelan Wilson, some of the most populated areas surrounded by schools and daycares. What do you think the construction of such shelters would do vis-a-vis crime to these residential neighborhoods?
There's about 30
Yeah,
seconds.
we can get you the data to show that when there's consumption sites in neighborhoods, violence, criminality, victimization all increase, and I can get you the information.
Thank you. Over to Mr. Saini for 5 minutes.
Thank you for taking the time to share your thoughts. Our government.
You're on. It's good. Gerbrooks, you're on.
Hello?
Yeah.
Our government has consistently said reform must be evidence-based, not slogan-driven. Conservative will say jail, not bail. But as expert, you have stressed the need for smart, targeted reforms. What message would you want Canadians to hear about why evidence-based reform is the right path forward? Mr. Sauvé, please.
I think anybody is familiar with Amazon. If I'm looking for a set of earbuds, am I just going to buy the first ones that pop up? No, I'm going to go in looking for something. I have my budget. I know what kind of quality I want. I'm going in with the evidence that I want to make a purchase. Canada is now going in seeking evidence from all of these witnesses through this study to figure out what's the best way we can federally and provincially and territorially make better bail decisions. That needs evidence. We don't have that yet.
Thank you. Youth exploitation, I heard several times. What do you think is the core reason of youth? Is it poverty? Is it new immigrants? It's our citizens from broken families. Mr. Stormtech, would you?
It's all of that. You've got kids that are coming into situations where they're being inundated through a variety of platforms, whether it's social media platforms or what have you, working in they're living in challenging socioeconomic environments. That you've got, in some cases, the breakdown of the family structure. In other cases, you've got people just trying to survive and make a living, so they don't have the time to invest in their kids. And so it's all of those things. It's a lack of programming, which creates vulnerability among the youth. And then you have predators out there that see that and take advantage of it and lure them into these kinds of criminal activities that create havoc in our communities and destroy their lives. So it's all of that, and we need to do better. And earlier you asked, what's the message? The message, I think, is the federal government's going to take a leadership role, and we're going to work collaboratively to get ahead of these issues. That's the message. That's what Canadians want to hear.
Thank you.
I would only add to my colleague's response about youth. What's the penalty? What's the consequence for recruiting youth into doing these things? So these are adults who are taking advantage of disadvantaged youth. There's no consequence for that. If they get arrested, they might be part of an organized crime ring. They might face charges for this, that, and the other thing, but there's no charge for taking advantage of the youth.
Mr. Campbell, you have said that there are many times when you see people committed crime, but you don't charge them. Is that also not sending a wrong message to the society that, so-and-so got off without doing, and I'm going to do the same thing?
Absolutely. And I mean, I hate coming back to resources, but we would need literally 100 police officers to go at any number of corners in the city of Toronto to try and enforce it. And so, as we've also mentioned, that when those charges would be withdrawn anyways, you start to get into the cycle of, and Tom mentioned it, why bother? Like, why am I going to go through this entire process, make an arrest, maybe have to have a physical altercation with somebody, seize the drugs, submit the drugs, this whole process only to see it withdrawn. So I don't disagree with you, but that's the reality of what's going on the streets.
Okay. Both the National Police Federation and Canadian Association of Chiefs of Police have said bail reform should be informed by strong partnership with law enforcement. What role do you see for ongoing federal police collaboration in reviewing bail outcomes and proposing further refinements?
Super brief answer from perhaps one of you. We're running up on time.
Start is you invited us to appear and provide you with some information, evidence. That's a good start. And then somebody mentioned some kind of a national summit where we get everybody together and try and come up with tangible, actionable solutions. That would be another great step in the right direction.
Thank you. Un autre 2 minutes et demie, s'il te plaît.
Mr. Fortin for 2.5 minutes. Thank you, Mr. Chairman. Gentlemen, I spoke about the fight against organized crime. It seems important to me. We spoke about young people who are recruited by organized crime. And I think it's probably 90% of the cases and this whole issue of drug trafficking and everything, it always, in my mind, comes back to organized crime. And you'll correct me if I'm wrong, but if we could do away with organized crime, it would be a lot safer on our streets. And I understand that you seem to be telling me that the current tools that we have do allow us to effectively fight against organized crime. So I'd like you to speak to us a bit about what tools we can use that have produced the best success against organized crime, because you're telling me that this register is not necessary. What tool has provided the most success?
We do lots of multi-jurisdictional things with the RCMP, with our other partners. The more opportunity to do that, when you do investigations, they take a lot of resources, they take a lot of people power, they take a long time, they're expensive. I mean, if there's resources to do that in Toronto, or a gang and gun unit or organized crime unit that works with other provincial and federal partners, if those resources are available, we can do more projects and take down more people that are out there committing the crime.
Mais vous me dites qu'actuellement.
But you're telling me that there are tools in place that we can use. So what are they?
Just to be clear, I'm not suggesting that a registry wouldn't be useful. I was talking more about how we would build that registry and what tools we would use to populate it. But there are examples of, there have been very effective examples of responding to, for example, outlaw motorcycle gangs by creating prohibitions against wearing of certain symbols. So those are the kinds of tools that are very effective when it comes to dealing with organized crime groups, and those can be expanded upon. We've had great success in...
les patchs, c'est ce que vous...
Banning patches, is that what you're talking about?
Oui, interdire les patchs. Mais on a aussi,
We've had great success using civil forfeiture rules, for example, when dealing, again, with outlaw motorcycle gangs, seizing clubhouses and other ill-gotten proceeds from crime, houses, cars, motorcycles. So there's tools that are available. We just need to use them better and more effectively.
Vous avez peut-être vu qu'au Québec...
My time is up? Okay.
5 minutes.
Thank you, Chair. Again, I want to thank all three of you for your attendance today. I just want to clarify something. This is our bail study. The Conservative Party advanced this bail study as priority number one at this Justice Committee, and it was the Conservative Party who invited all three of you to attend, so we're very grateful for your attendance. Now, it's amazing. This is a question to you, Mr. Campbell. It's amazing what you can find on social media. I was scrolling social media during the last half an hour or so. Yesterday, downtown Toronto, on a busy street, captured by video surveillance, is a gentleman, I'll use the term very loosely, standing on a sidewalk, assembling what appears to be an AK-47 in broad daylight in heavy traffic. Do you think that type of person, or the gangbangers, or the thugs that are terrorizing our communities from coast to coast,
Mr. Brock,
would be...
there's a point of order from Mr. Cheng.
Joint study.
I think you said, Mr. Brock, that it was considered. I think it is, in fairness, a joint study. And
It's a joint study, but the bail issue was a Conservative motion,
Okay, well,
Mr. Chair.
Thank you for the clarification.
Yes.
And in fairness, there were witnesses that were brought forward that weren't solely from the Conservative list. If the clerk correctly, I have no reason to question that. 2 and 1, yeah, okay. Anyway, that is what it is, but just, we froze your time, so please go on.
My time is frozen, thank you. So you tried to ruin my clip, but we're going to get it back on track. The thug that I just described to you on a downtown Toronto street, is that the type of person or a gangbanger that would likely want to return that particular AK-47 as part of the Liberal buyback program?
No, and we've said it many times. The gun buyback program will not impact the violence we're seeing in the city of Toronto. Rediverting some of those resources would.
Thank you. I was very fortunate enough to attend TPS about 3 weeks ago this Friday, had a ride along, saw firsthand what you're describing to this committee, but I also received a number of startling statistics in terms of the number of people out on bail on murder charges and serious gun crimes. Do you have any statistics today or within the last few days to share with this committee as to the number of people in downtown Toronto on bail?
I don't, but I can get that for you, absolutely. But I do want to mention, as it came up around youth, we had over a dozen youth charged with murder this year in the city and 102 illegal firearms seized from youth in the city. I think it's an important stat.
And you have youth as young as 12 years of age on bail right now for first-degree murder. Is that correct?
We do, and it is completely common to see someone out on bail either for a previous shooting or firearm charge. It happens all the time.
Thank you. Chair, I'm going to cede the rest of my time to Mr. Shipley.
We have a little over 2 minutes.
Thank you, Chair. Thank you for giving me that time. I think we'd be remiss if we didn't have a little bit of a conversation today here about the actual frontline officers, the men and women who serve our communities. I'd like to mention 2 tragic incidents that have happened over the past couple of years. Last year, there was Constable Jim Peters, a Barrie police officer, was stabbed while on duty by a repeat violent offender who was on probation at the time of the stabbing. Thankfully, Jim survived that attack. But in 2023, OPP Constable Greg Priscilla, who is a Barrie resident, was ambushed and murdered by a violent repeat offender who was out on bail under a lifetime firearms ban. Gentlemen, you 3 represent a lot of officers. You're the presidents of your association. I think we need to talk about how these type of incidents, how these repeat offenders are affecting the wellness and the mental health and the morale of your officers.
I just partnered in I just partnered in a research project with Dr. Nick Carlton at University of Regina. We looked at publicly available data from 2011 to 2014. We had over 245,000 assault police officer charges laid in this country. Our police officers, our members, are being assaulted in this country by these offenders that we're talking about every day. In April of this year in my home service in Vancouver, we had an offender try and light a police officer on fire by pouring a flammable fluid on the officer while the officer was in the process of trying to arrest this individual. That's just one example. You've alluded to others. There are many other examples of police officers getting stabbed, seriously assaulted, and all of those, fortunately, did not become those kinds of tragedies like happened to Constable Priscilla. So it's happening every day. We're not paying enough attention to it, and we ought to, because we're also experiencing a massive recruiting retention challenge in our sector right now, and in part, it's because of that. Because why would somebody want to come into a regime where they're exposing themselves to this kind of risk every day, but then are not being supported by heads of institutions, by elected officials, in some cases, by other statutory bodies that are in place that are tasked with investigating these incidents when they happen. So it's a real challenge.
That completes Mr. Shipley's round, and we're finishing off with Mr. Chang for the final 5 minutes.
Chair. Thank you, gentlemen, again. Burnaby Central is one of the most diverse communities in Canada. We have many youth families. Victim families, police officers, community groups often bring different perspectives. So in each of your view, how do we best balance the need of public safety with fairness and judicial independence?
I mean, if you speak to the community, the members that are out there, they're sick of the violence. They're sick of the violence. They're sick of what they're seeing out there, and they want to see some change. They need to focus back on the victims, the communities, the people that are trying to go about their daily lives without being fearful of violence or being shot or stabbed or carjacked. That's the balance. The balance needs to swing back to the victims in the communities and not the offenders.
You have well, in Burnaby particularly, you have a brand new officer in charge of that detachment, and I would encourage anyone from Burnaby to walk in and talk to him. He is more than willing to talk to anyone from the community about their priorities, their perspectives, and their experiences. And I would suggest that goes for any chief across the country.
Our services, particularly on the front line, have become more and more diverse. We're better represent the communities that we police. We have more women in policing today than we ever have before. Every police service across this country has got numerous advisory committees, other mechanisms for consulting with the community and hearing feedback from the community. And unequivocally, the feedback is we got to do something about violent repeat offenders in our communities.
Thank you. And one last question. Looking ahead, what should Parliament keep in mind as the government prepares to introduce new legislation on bail and repeat violence offenders this fall?
Keep in mind?
Yeah, what should
I
Parliament
think you
keep in
should
mind?
take a look at what I talked about earlier on. I deal with an NDP mayor. The chair of our police services board is a Liberal. We have a Conservative premier, and we come together and get stuff done. So I would ask both sides. I understand there's politics, but let's put our communities and the victims first and come together and pass something that's actually going to help keep our communities safe.
Let's keep it short, what he said.
And also bring in the provinces and all levels of government to participate in whatever the proposed legislation is so that there's some actionable items that come from it.
Thank you, gentlemen.
We done?
Yep.
Members, this completes the meeting today. I want to thank the witnesses for their testimony today. I want to thank you individually for your service and as well as the service of the members that you represent in keeping Canada and Canadians safe. Il n'y aura pas de séance mardi en raison.
There will be no meeting on Tuesday because of the National Day for Truth and Reconciliation, as you know. And therefore, our next meeting will be on Thursday, the 2nd of October.
We want a full roster for next Thursday, so members, if you could send in your lists, we'll have a complete session next Thursday with a full set of witnesses. And I do presume that is the will of the members to adjourn the meeting. Do you have a lot? Do you want to go in camera? Or do you want to? Sure, go ahead.
Thank you, Chair. There is a very high Jewish holiday next Thursday. Nonetheless, there's also, I guess, a possibility that one of the ministers will attend. If my colleagues across the aisle know that none of the ministers will make themselves available next Thursday, could they please let me know?
I think that's fair, yeah.
We'll
get that information to your teams. Yeah. Okay. Thank you. Meeting adjourned.